1984, Gregory Lee Johnson traveled from his home in Georgia to the city of Dallas, Texas, where the Republican National Convention was scheduled to be held. Johnson went to Dallas to protest the policies of the Reagan administration, as well as some Dallas-based companies. Along with about 100 other protesters, Johnson marched through the streets of Dallas, finally arriving at Dallas City Hall. It was then that Gregory Lee Johnson was handed an American flag which had been taken from a flagpole from one of the Dallas companies. He doused the flag in kerosene and then set it on fire.
There was a statute in the Penal Code criminalizing the desecration of the American flag. He was charged with violation of this flag desecration crime found in the Texas Penal Code. He was convicted. He obviously violated the law as written.
And the desecration was legally defined as damaging or harming the national or state flag in a manner that the person damaging it knew would likely give serious offense to someone who was going to observe it. So the law did not apply to someone who burned a flag inside his own house or in the backyard, but to do so with knowledge there were others nearby and with knowledge that those persons would be offended.
Having been found guilty by the Texas District Court of the desecration of a venerated object, Gregory Johnson was sentenced to 1 year in jail and ordered to pay a $2,000 fine. He appealed his conviction to the Texas Fifth Court of Appeals, but that court upheld the conviction. The Texas Court of Criminal Appeals, however, reversed the judgment of the lower court and thus overturned Johnson's conviction. Following this decision, the state of Texas requested that the United States Supreme Court hear the case. Texas versus Johnson would require the court to answer whether or not the desecration of an American flag by burning or otherwise was a form of speech that is protected under the First Amendment.
One argument is that flag burning is in fact speech. It is expressive in nature. Johnson needed to show that in fact it was expression, that it was symbolic speech or just flat out pure speech. He was expressing his extreme discontent with the country, with the flag, with the Republican convention. We're not sure what he was very upset, and he was making that relatively clear.
And of course, the state was arguing that, no, that's conduct, that's not speech. You have all manner of ways to criticize the Reagan administration for the policies that you observed during the first 4 years. Burning the flag is not essential to making your political point, your politics known. And burning the flag should not even be considered speech protected by the First Amendment.
But the court said, this is symbolic speech, this is speech, this is conduct which equals symbolic speech because clearly it was intended to and clearly understood to convey a political message.
The second question was, given that it's symbolic speech, does the government have a sufficient interest in restricting it? So someone might say, for instance, the reason I'm burning leaves in my backyard is because I wish to convey my contempt for trees and for their disgusting leaves. A municipal ordinance that prohibits that typically is not an anti-tree hater law. It's designed for the public safety. The municipality might very well say, we hate trees as much as you do. We're simply trying, however, to prevent the fire hazard that arises when people are lighting fires in their own backyard. In this case, the court held that Texas was upset with the flag burning precisely because of its message. And that, according to the Supreme Court, triggered a very heightened standard. The state of Texas had to show a very high, very important interest to suppress a symbolic act precisely because of the message the person wanted to convey. The state of Texas said, we have such interests. We have two interests.
The state said, number one, we are prosecuting Johnson under this statute to serve the legitimate interest of avoiding breaches of the peace. Flag burning is very controversial, and if someone burns a flag in public, there's a likelihood that there may be a fight or a riot. He might be attacked by bystanders. That didn't work in this case because there was no proof in the record whatsoever that there was any likelihood of a violent reaction or a hostile reaction. The second justification was that the flag is special, the flag is different. The flag is a unique symbol of national unity. The flag has a symbolic and emotional meaning to the American people that virtually nothing else does. And consequently, the flag should be protected against mutilation or defacement because it is this nearly sacred symbol of national unity that people of very different ideological persuasions can all accept as kind of molding us together.
And the United States Supreme Court said, we don't think that's a compelling interest. If that's a compelling interest, protecting dignity and preventing people from being offended, then there's no bottom there. This time it's burning the flag. Next time it's holding a sign up that disrespects a president or a particular political party. In a government of, by, and for the people must be permitted to speak freely, to express themselves freely, particularly when the subject of that expression is concern or complaints about those clothed in governing authority. That's the essence of a constitutional democracy.
In 1989, 5 years after Gregory Johnson set fire to the American flag on the steps of Dallas City Hall, the U.S. Supreme Court, in a 5-4 decision, held that his action was protected expression under the First Amendment. The court found that Johnson's actions were of a distinctively political nature and fell into the category of expressive conduct. Freedom of speech, the majority ruled, did not end at the written or spoken word.
It's the idea that it has communicative value and it's understood to communicate an idea. So when expression is understood, it can be nonverbal expression. So to the extent that the message was understood and conveyed, the court said it represents symbolic speech. It was understood as an idea, even though the speech was nonverbal in terms of words.
A rare coalition comprised the majority, Justices William Brennan, Harry Blackmun, Anthony Kennedy, Thurgood Marshall, and Antonin Scalia. Writing for the majority, Justice William Brennan asserted,
"We do not consecrate the flag by punishing its desecration, for in doing so we dilute the freedom that this cherished emblem represents. The way to preserve the flag's special role is not to punish those who feel differently about these matters. It is to persuade them that they are wrong. Government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable."
The majority explained that even though some ideas may be offensive to others, the government may not prohibit the expression of those ideas.
Justice Brennan, writing for the majority in Texas versus Johnson, concludes that the government interest is in fact speech-related. The government wants to preserve the sanctity of the symbol as a symbol of unity. Presumably under the Texas statute, if Johnson had been a Marine, respectfully burning a flag that had been defaced, as would be the military custom, he would not have committed an offense because he, number one, he would not be intending to offend anybody, and he would not be presumably would not be offending anyone who was aware of what he was doing. So the government's interest here was very definitely aimed at the nature of the expressive aspect, and consequently the highest standard of review applied. And that's a standard that is very, very hard to meet. In this particular case, the only real argument that the government had was that the flag is unique, that there ought to be kind of something of a flag exception to the First Amendment, and the court was unwilling to buy it.
In his concurring opinion, Justice Anthony Kennedy explained,
"The hard fact is that sometimes we must make decisions we do not like. We make them because they are right. Right in the sense that the law and the Constitution, as we see them, compel the result. The flag is constant in expressing beliefs Americans share, beliefs in law and peace, and that freedom which sustains the human spirit. The case here today forces recognition of the cost to which those beliefs commit us. It is poignant but fundamental that the flag protects those who hold it in contempt.
Mr. Johnson was affiliated in some way with communism and the promotion of communism, and the First Amendment protects even speech that the vast majority of Americans find offensive, even those beliefs that are most offensive to us, to the majority of us, and even for those who express themselves in the most offensive ways. For the First Amendment to be vital, those persons must be protected by the First Amendment.
4 dissenting justices disagreed with the majority's reasoning. Chief Justice William Rehnquist wrote a dissenting opinion, which was joined by Justices Byron White and Sandra Day O'Connor. He wrote,
"Flag burning is the equivalent of an inarticulate grunt or roar that, it seems fair to say, is most likely to be indulged in not to express any particular idea, but to antagonize others. The Texas statute deprived Johnson of only one rather inarticulate, symbolic form of protest, and left him with a full panoply of other symbols and every conceivable form of verbal expression to express his deep disapproval of national policy. It was Johnson's use of this particular symbol, and not the idea that he sought to convey by it, or by his many other expressions, for which he was punished."
Justice John Paul Stevens also dissented. Reading his dissent from the bench, Justice Stevens said,
"Sanctioning the public desecration of the flag will tarnish its value, both for those who cherish the ideas for which it waves, and for those who desire to don the robes of martyrdom by burning it. The ideas of liberty and equality have been an irresistible force in motivating leaders like Patrick Henry, Susan B. Anthony, and Abraham Lincoln, school teachers like Nathan Hale and Booker T. Washington, the Philippine scouts who fought at Bataan, and the soldiers who scaled the bluff at Omaha Beach. If those ideas are worth fighting for, it cannot be true that the flag that uniquely symbolizes their power is not itself worthy of protection from unnecessary desecration."
The U.S. Supreme Court's ruling in Texas v. Johnson invalidated laws regarding the desecration of the American flag in 48 states. In 1989, Congress passed the Flag Protection Act, which made it a federal crime to desecrate the flag. This law attempted to restrict only the action of desecrating the flag rather than the symbolic nature of doing so. However, that law was struck down in another Supreme Court case by the same majority that had ruled in the Johnson case. Since that time, some members of both houses of Congress have introduced a proposed amendment to the Constitution to overrule the court's decision in Texas v. Johnson. It has passed the House of Representatives by more than the 2/3 vote required, but the proposed amendment has failed in the Senate to get the required 2/3 vote each time the Senate has voted on it. The most recent attempt to adopt the amendment failed in the Senate by 1 vote in 2006. Today, more than 20 years later, the issue involving the desecration of the American flag remains controversial.